Hello, everyone. So we are going to get started with the Civil Liberties and Civil Rights chapter. This one's probably about the longest one we do, but generally is one of the most interesting. So civil liberties will be the 2/3 or so of this chapter. Civil liberties are your protections that are found in the Bill of Rights, so your first 10 amendments. And civil rights are basically, as I said in the last chapter real briefly, the civil rights come from the Equal Protection of the Laws Clause of the 14th Amendment. And so we'll do that at the end of this chapter. The U.S. government has been a party to more Supreme Court cases than anybody else now. Second in terms of times being involved in a case is the ACLU. So the American Civil Liberties Union, you'll see that name in some of the cases we do, and sometimes even if they're not in the name, they will provide a free legal counsel, a free lawyer for somebody there. They were created in the early 1900s as people were protesting against World War I and the draft. And so they protect your civil liberties, especially First Amendment and freedom of religion rights. They are, again, some would say a divisive organization because some would say they're far, far left and they can be pretty radical, but they really are there to protect our rights. If you ever see the ACLU, a party to anything or raising questions about some issue or something like that, they've been around for about 100 years. Now, in the original Constitution, there were not that many protections to civil liberties. They did have, in Article 1, Section 9, they mentioned these three that are underlined, where everybody has the right of habeas corpus, which is basically to know your charges, to know why they are holding you, and then you get the right to defend yourself and get legal counsel, and the government can't keep you in jail indefinitely without being able to defend yourself. And no bills of attainder. Bills of attainder would be Congress passing basically like a bill or a law that punishes somebody. It's up to the courts to issue the punishment, so Congress can't do that. And then no ex post facto laws. And ex post facto laws would be laws that where, let's say, you were using a cell phone today, and then tomorrow the government passed a law saying you could not use your cell phone, and then they went back and punished you for using it the day before. They can't go back after the fact and punish you for something. Just a reminder, the Civil War amendments, the 13th, 14th, and 15th amendments, they were 13th ended slavery, the 14th made ex-slaves citizens, and then also included equal protection of the laws. And then the 15th Amendment gave African Americans, gave black people, former slaves, the right to vote. Now, just to skim through the amendments, the First Amendment has 5 or 6 parts to it. Religion is split into 2 parts, the establishment of religion and the free exercise clause, and speech, press, and the right to assemble and petition. Amendment 2 is the right to bear arms. Amendment 3 has to do with quartering of soldiers. Amendment 4 says no unreasonable search and seizures. Basically, you need probable cause, you need a search warrant. Amendment 5 has a lot of parts to it. And I guess the big ones would be, a lot of you know, like plead the fifth. Like you don't have to testify if it's going to incriminate you. You can't take away due process of laws in there. No double jeopardy. At the very end of it is just compensation or eminent domain, if you know what that is. Amendment 6 deals with like trial and lawyers. Amendment 7 is not one that we ever really deal with. That deals with civil lawsuits. Amendment 8, no cruel, unusual punishment. Amendment 9 is basically rights we left out that we give the people. And the 10th Amendment gives powers to the states that are not given to the national government. So now we'll start with some of these cases. And I know this gets sort of overwhelming with all the cases we do. But I wanted to start off by really getting to this case, the second one there, Barron v. Baltimore. Barron v. Baltimore in the 1830s, 1833, Barron v. Baltimore said the basics of it was the decision said that the Bill of Rights only applies to the national government, which meant states could ignore the Bill of Rights. So that was a huge decision. States could ignore the Bill of Rights. It was a case about eminent domain or just compensation, where this guy, Barron, was suing the city of Baltimore because his business was basically like a wharf, a dock, and he would unload stuff off boats and then get it onto horses and stuff to transport it, to bring the goods wherever they were supposed to go. Well, the city of Baltimore did work in the harbor, and it caused sediment to build up under his dock, and then no one could get to it with their boats. And so he basically sued Baltimore and said, you should pay for this. And Baltimore said, no, we don't have to pay for this. And the Supreme Court agreed. The Supreme Court said Baltimore doesn't have to listen to the Bill of Rights. All right, so basically, the Bill of Rights then did not really apply to state and local governments till mostly the 1900s. So more than, well, now I guess it's not quite more than half of, more than half of American history, at least the vast majority of the Bill of Rights did not apply to the states and to the local governments. And then the process is going to change. This is a really, really important definition here. It can be called incorporation or selective incorporation. So selective incorporation is the process of making the Bill of Rights apply to the states on a case-by-case and clause-by-clause basis using the Due Process Clause of the 14th Amendment. Now, what that means is a case has to come up, say, on right to assemble. The case has to come up, the court has to hear it, and the court has to say, yes, local and state governments have to listen to the right to assemble. And that would just be that one clause. Then there would be another case on another clause, and another case, another clause. And so this has been an ongoing thing that is not quite completed. It's very near completed. It's a little frustrating because I wish there had just been one decision overturning Barron v. Baltimore and making all the local governments in the country, including state and local, have to listen to all parts of the Bill of Rights. But the court felt that some of the rights listed in the Bill of Rights are way more fundamental than others, and so they wanted to decide it on a case-by-case basis, which has then led to tons of cases. So 1925 was the first of these. And so in 1925, the court incorporated free speech. So don't worry about the details of that case, but basically what that meant is that's the first time. Now, the states protected free speech generally anyways, but this is the first time that the states and local governments after that had to listen to the First Amendment free speech clause. All right? And that's the first really major part of the Bill of Rights that gets incorporated. There was an earlier case, you see down below a little bit, Chicago, Burlington, and Quincy Railroad Company versus Chicago. What happened, and this really is the one that deals with the specific topic of Barron. There was this railroad company, and they had a railroad going through Chicago, and Chicago decided they were going to change their layout of their roads, and they were going to turn their roads into more of a grid system, so it was easy to navigate, not just like random roads going all over the place. So it was just straight down. If anybody's been to downtown Chicago or really downtown New York, it's very easy to navigate. It's just First Street, Second Street, Third Street. They were going to do that. So when they went in and were going to lay out the roads again, well, there were railroad tracks going right through one major intersection. So they told the company, you have to move that. And the company said, we'll move it, but you have to pay for it. And the city of Chicago said, no, we don't, because of the Barron case. So they went to the Supreme Court again, and the Supreme Court actually said, no, the cities have to listen to the just compensation or eminent domain clause also. And that was the very first part of the Bill of Rights that was incorporated that states had to pay attention to in that specific case. So that case there basically incorporated eminent domain. Specifically in that case, though, it was kind of funny because Chicago was like, what, you're going to rule against us? I mean, this, when they start reading it, because that's not really fair. We were doing what we were told basically by the court, that we didn't have to pay for any of this. And the court basically wanted to set a precedent, but they really didn't want to punish Chicago. So they ruled in favor of the railroad company. And they said, yes, from now on, cities have to listen to the Bill of Rights. And we're going to award this railroad company from the city of Chicago $1. So it was stupid, really. It was more of just a symbolic gesture. All right, so anyway, so we have now then looking at that, In the 1897 case in Chicago, we've incorporated eminent domain. In that first one, Gitlow v. New York, we've incorporated free speech. So just to show you how it works with the last two cases here, Cantwell v. Connecticut and Everson v. Board of Education, well, there's two parts of freedom of religion. So you needed two separate cases to incorporate it. So Cantwell v. Connecticut incorporates the free exercise clause, and Everson v. Board of Education incorporates the establishment of religion clause. So if you get those, we're okay. So Cantwell incorporates the free exercise clause, and Everson v. Board of Education incorporates the establishment clause. Now, just specifically real fast on these, Cantwell v. Connecticut was about Jehovah's Witnesses who were going door to door. They were trying to get people to convert to their religion, and people in Connecticut weren't happy about it, so the government passed a law saying basically no going door to door. And the Jehovah's Witnesses challenged, and they said, well, that's our way we exercise our religion. That's integral to our religion, is going and introducing ourselves to people and trying to push our religion. And the court agreed. The court said we have to let them exercise their religion. You can't just put a blanket ban on going door to door now. Homeowners associations can, or individual homeowners can, but not a city or a state. So they incorporated free exercise clause. Well, then 7 years later, you have another case, and this case is about someone upset that buses were bringing kids to religious schools. So I'll just make it up and put it in today's terms. Let's say that you lived in Wellesley, your next door neighbor, also lived in Wellesley, and you went to Green Hope, and your next door neighbor went to Cardinal Gibbons. Well, this would be a situation where, let's say that the Wake County school bus picked both of you up, brought you to Green Hope, dropped you off, and then brought your friend who goes to Gibbons, brought him to Gibbons and dropped him off. Well, that's basically what was happening. And this guy was mad because he said, my tax dollars should not be going to help support a religious school. He said that's like the government establishing or endorsing, in that case it would be like the Catholic Church, I guess, the Catholic school. And so the Supreme Court agreed that the government, the local and state governments, had to listen to the First Amendment Establishment Clause. But in that case, they said, too bad, it's not establishing religion. They go, it's not really helping the Catholic Church. It's just letting a kid whose parents pay taxes get to school safely. So we don't do that here in Wake County like that, obviously, but they're saying, look, it's just like fire protection or police protection or something, firemen or police protection. Don't worry about it. It's not really establishing religion. But in the future, local and state governments all have to abide by the Establishment Clause. So understand incorporation, very important. Most recently, the Second Amendment has been incorporated, so we'll get to that soon. The grand jury clause in the Fifth Amendment has not been incorporated yet, so states don't necessarily have to give that. But it's mostly been completed. The one thing that's crazy about it for some people is if the definition is making the Bill of Rights apply on a clause-by-clause basis to the states. Well, there are cases like Griswold v. Connecticut that incorporates the right to privacy. But then you look at it and you're like, oh, wait a minute, the right to privacy is not even in the Constitution. How is that an incorporation case? But it is considered one. The Miranda warnings, if you know that case, that everyone's guaranteed to be read their rights. It doesn't say that in the Constitution, but that is an incorporation case. So all states and local governments have to listen to that. They have to give everybody the constitutional right to have their rights read to them. So incorporation cases, there are even more incorporation cases than there are clauses in the Bill of Rights. So there's a lot of incorporation cases. Anyway, just over 14 minutes, so I will stop it there, and we'll get to free speech tomorrow. Thank you.